Okay, good morning, members, and welcome to this meeting of the Economy Committee. We're joined in the room by Mr. David Honeyford, Ms. Diane Armstrong, and joined online by Sinead McLaughlin and Padraig Delargy. And we're hopefully going to be joined shortly by Jonathan Buckley and Kate Nicholl. And we've apologies from Emma Sheeran and Mr. Philip Brett, the chairperson. Okay, members, so we're in public session. We just remind members to switch off their mobile phones or put them onto mute. And if there are any declarations, can members indicate at the relevant time throughout the committee. There's no chairperson's business. Draft minutes, members, refer to page 7 of your packs. You'll see a draft minute from the last Economy meeting on the 22nd of October. Are members content that the draft minutes are an accurate and complete record of the committee's deliberations? Yep, okay. Again, members, I refer to page 19 where there's a copy of the draft committee meeting from the 5th of November. Again, members, are you content that this is an accurate and complete record of our deliberations? Yeah. Matters arising, members, does anybody have any? I don't have any. Are we content to move on?
Yeah.
Yep. Okay, members, I'm going to seek your permission that we move into closed session to discuss the next item on the agenda in relation to the Insolvency Bill. Members agreed?
Yeah.
Okay. Okay, members, we're back into public session and we're going to now move on to the officials are going to come and discuss the Insolvency Bill with us, and we're going to informally go through clause by clause at this stage. A reminder that no votes will be taken, and the formal clause by clause will follow in 2 weeks' time when votes may be required if there's a difference in terms of agreement. Okay, just welcome Mr. Jack Reid and Mr. Richard Monds, both from the Insolvency Department and Department for Economy. You're very welcome. Clerk, we're going to make a start at clause number 1.
So just for the benefit of officials, what I'll do is I'll summarise very briefly what the clause is and ask if the officials have anything to add, and then we'll take members' temperature about what they want to do. This might take a while, so but there we go. Okay, so members.
Sorry, Chair, through the chair, have you got a specific page in our packs, Peter, that I can refer to?
Sorry,
Page 65.
Page 65. So if you start going, I'll give you the page numbers every time. So it's
Okay, thank you.
there's we've a little evidence table. There's not that much evidence in it, but there is an evidence table. And if you have a copy of your bill, I find it very handy to look at that. If okay, that's in your packs too. If you look at the explanatory and financial memorandum. So beginning then, clause 1 is entitled Introductory and is at page 65 of your packs. The clause is described as providing information about the origins of parts 2 to 10 of the bill and about the amendments made by parts 11 and 12. So it's basically just sort of foundational to the rest. I guess does the department have anything to add? Can I ask?
Nothing more to add.
So, Chairperson, can members confirm that they understand the clause and do they have any questions or comments on it?
Are members then content that we informally agree with the clause? Yep.
So you're informally agreeing that the clause stands part of the bill. That's agreed. So moving on then, clause 2. Again, this is at pages 65 to 66. This is called Power for Administrator to bring claim for fraudulent or wrongful trading. The clause makes 3 insertions into the Insolvency Order 1989 around the assets of companies where there has been wrongful trading. Again, Department, want to clarify or add anything on that?
Nothing to add, no.
So again, members, do we understand the clause?
Yeah.
And there was no amendments were actually proposed to it, so...
Are members content that we informally agree clause 2?
Yeah.
Yeah.
Good. 3 then, power for liquidator or administrator to assign causes of action. So this is at pages 67 to 68. The clause is described as enabling liquidators and administrators to take action on behalf of the body of creditors to recover monies or reverse certain transactions where directors or others have acted in a way that has caused harm to creditors. There was contradictory commentary on this from the Bar of Northern Ireland and the Insolvency Practitioners Association, which is summarised in the table. Can I ask if the department has very kindly responded on these matters anyway, but did they have anything further to add?
Nothing to the response we provided previously.
So can I ask, Chair, if members understand the clause and the commentary that we received around causes of action?
Yes.
Good. So are you content that the clause as is stands part of the bill informally? Fab. Clause 4 then, application of proceeds of officer claims. This is at page 68. So this clause is described as ensuring that the process of certain claims do not form part of the company's property, which is available to satisfy debts secured by floating charges. Now, floating charges are held by creditors who own stock or raw materials in the insolvent company. The intention appears to be to ensure the provision of assets for unsecured creditors. Again, if the department want to...
No, that's a very good summary.
So members confirm that they understand the clause. Remember, if you don't, good time to ask. Can I ask if they understand? And no evidence or amendments were proposed. So can I ask if the committee is informally content for the clause to stand part of the bill?
Yeah.
Fab. Number 5 is exercise of powers by liquidator, removal of need for sanction. That's at page 69. The clause is described as allowing liquidators the power to take action without the sanction of the High Court. Again, does the department want to add to that?
No, nothing to add to that.
And so can I ask if members understand the clause?
Yes.
Yeah. And nobody said anything about it, so are you happy for it to stand part of the bill?
Yes.
Fab. Brilliant. 6. This is the exercise of powers by trustees. Exercise of powers by trustee in bankruptcy, removal of need for sanction. This is at page 69. The clause is described as allowing trustees in bankruptcy the power to take certain actions without the sanction of the High Court. Again, the department happy with that. Then can I ask if members understand that clause?
Yes.
And are you happy that it stands part of the bill? Informally, yes. 7 then, abolition of requirements to hold meetings, company insolvency, and this is at page 71 to 73. Currently, decisions made by creditors in corporate insolvency proceedings have always been at physical meetings. The clause is to provide that physical meetings will no longer be the default mechanism for seeking decisions from creditors and contributories in corporate insolvency proceedings. The clause also sets out a deemed consent procedure whereby anyone seeking a decision from a company's creditors or contributories will be able to write to them with a proposal, and unless 10% or more of the creditors or contributories by value object, the proposal will be deemed to have been accepted. Clause 8 covers similar ground for individual insolvency. Now, there was commentary from the Bar of Northern Ireland around the use of virtual meetings. Assurances were provided by the insolvency practitioners in respect of deemed consent. They liked the idea. So can I ask, Chairperson, if the department has anything to add?
No, as I said, we had provided quite a detailed response on that one from the bar. We understand that there's probably no ideal way of arranging meetings. So we looked at providing information digitally. So we are looking to ensure that extends to as many people as possible. So I know that some of the bar were concerned that maybe people who weren't aware of digital or hadn't digital means of communication would be left out. So we're looking at what other things can be put in place to ensure that we get as many people as possible. So we are continuing to look at that.
You say you're looking at other, do you mean in terms of?
In terms of, for example, I've suggested that not everybody has access to digital means, but there are means by which people can phone in, for example, into a meeting rather than having to be part of a Teams meeting. There are certain means around that, so those are sorts of things we're looking at around that to ensure that nobody is really disenfranchised from the process.
And you're content as the bill as presented would allow for that?
It will do, yes.
Okay. Sinead, do you have anything to add in respect? I know you'd raised some issues informally in relation to the virtual meetings and ensuring equal access, I suppose, across the board.
Hold on, I'm trying to unmute Sinead. Sorry, okay, there you are.
No, I absolutely I support the virtual meetings, but just I kind of want to make sure that those that might not have digital access would have the ability to call in-person meeting. And I note that there's 5 business days have to be given before you can have an in-person meeting, and I'm wondering why is it so restrictive? Can you give us any further detail on that? And is it something that we could have more flexibility within the bill in relation to it?
Yes. Well, the intention is that it will be possible for creditors to take part in virtual meetings, so meetings are not being done away with altogether. It's just that the means by which they are to be conducted is to be changed. But I think what it is important is to ensure that those who would be entitled to take part in the meeting are made aware of their rights to do so, even if they don't have the necessary means to allow them to take part electronically. And the alternative, as Richard has said, would be to allow them to take part by telephone. And what I'm looking into is, should provision be in legislation to actually require the person who's convening the meeting to alert those entitled to attend that they have the right to ask for to be able to attend the meeting using alternative means, that is by telephone. But any provision to require the office holder to do that would be the appropriate place to include it would be in subordinate legislation. You see, the intention, this is only the framework, and the detail, there's a lot of detail about this, will go into subordinate legislation in the form of a set of rules, and we would see that as an appropriate home for to place a requirement on insolvency practitioners to alert creditors as to their rights. The requirements for notice of a meeting will also be in rules. Now, a complete new set of rules has been made in England and Wales, which consolidated the previous rules and modernised them as the Insolvency England and Wales Rules 2016, and those will have to be replicated for Northern Ireland. And Rule 15.3 of the English rules sets out the types of the means which can be used to seek decisions from creditors, or in the case of companies, their contributories. And those means are listed as correspondence, electronic voting, virtual meeting, or a physical meeting. Well, of course, under the primary legislation, the intention is that it will only be possible for a physical meeting to be held in limited circumstances if 10 creditors or 10% of the creditors by number or value request it. The other means which can be used to make decisions is described as any other decision-making procedure which enables all creditors who are entitled to participate in the making of the decision to participate equally. So that would allow you to offer creditors the option of being able to phone in to a meeting if they didn't have the means to access it by computer or using an iPad or using a phone, a smartphone. You mentioned the notice which has to be given of decisions, isn't that right?
Yes.
The notice requirements. Well, notice of decisions.
Notice of a physical meeting for 5, you have to 5 business working days or something.
Is that in the I don't think that's in the primary legislation. Am I right? Where do you know where the reference to 5 days is? 5 business days?
Where it's just sitting out of the right.
Electronic voting.
Is it in the Insolvency Rules Review
Meetings.
I
document?
think it's on page 57, 58 of our pack.
You have that.
I don't have the pack.
Notices to creditors. I don't think that there's any reference to a specified period of notice having to be given to those being invited to a meeting in the primary legislation. I can't see any, but what I do
It's just no.
It's in the Insolvency Rules.
Insolvency rules.
Yeah.
So
Mm-hmm.
the English rules?
Okay, so what you're saying, Jack, is that there's
What-
there's no time period then on the face of the bill at all?
Primary
not
legislation.
in the primary legislation. So the issue of what the minimum period of notice should be wouldn't be something to be dealt with in primary legislation. But what I do see here in English rules, which are to be replicated for Northern Ireland, is Rule 15.8,
Yes.
notice to creditors of decision procedure. So that should tell us what the anticipated period is to be. This rule sets out the requirements for notices to creditors where a decision is sought by decision procedure. The convener must deliver a notice to every creditor who is entitled to notice of the procedure, and then it lists what the notice must contain.
Okay.
The notice must be authenticated. But when does that, what's the period of notice which has to be given?
I think maybe the way to take it forward is, will the committee accept insurance if the rules will set this out very clearly, and we can get the minister to even say it at consideration stage?
Yeah. No, I think that's right. I think it is important that we just get the clarity in terms of this being set out.
Back to it.
We'll certainly come back to it in terms of the formal, but I think it's important that the minister, sets out that some of the concerns raised by the committee, that they're reflected in the rules when those are published.
Sure. Yeah.
Correct.
I found here. It's set out actually in a table in Rule 15.11. Notice of decision procedures and notices seeking deemed consent must be delivered in accordance with the following table. And then it lists the various procedures in relation to which meetings can be convened. And the usual period in this table is 14 days. There are some procedures in which a shorter period is prescribed. In the case of what is termed a moratorium under Part 1A of the Act, we have a moratorium here. The minimum notice period is 5 days, but it's only in relation to that procedure. The rest of the procedures, there's most of them have a requirement for a minimum of 14 days. And bankruptcy decisions of creditors and appointments of a new trustee following removal of the previous trustee, the minimum period is 7 days, but for most of them is 14.
What I'm going to do is I'm going to get the clerk just to summarise just in terms of the position that we had discussed in relation to the committee, and then what potential options we have just in terms of getting that clarity that Sinead and others have asked for, and making sure that people aren't disadvantaged in terms of whether they're virtual or whether they want a physical meeting or a phone call, if that's the method.
So, members, it's pretty clear that the committee is concerned about the default move away from physical meetings to virtual meetings, because you all probably know people who don't have access to, as I do, who don't have access to digital assets, or if they do, they couldn't use them. So what you could do is you could seek an amendment to the bill to clarify, or what you could also do, as the department's indicating a lot of these rules will be specified in regulations, is that we could write to the department, seek an assurance from the minister that when the regulations are brought forward, that they will clearly indicate that people who don't have access to digital assets will certainly be included, and that you could also require the department to review how this is going, and that this could all be covered then in regulations, so that rather than amending the bill, so one, you could amend the bill, two, not amend the bill, but get the minister to give you an assurance that when the regulations come forward, they will take account of the committee's concerns, and further, the department will actually review how that's going, and to make sure that there is no exclusion for those who you may very well know in different parts of the country that may not have access to digital media. So can I ask where the committee is with that? Is it the first or the second?
Or is there an issue in terms of doing both in parallel? In terms of scoping out the potential of, I'm just in the interest of time. My point being is that if the minister is going to give assurances, then that is good and that is important. My point being is that if the bill office are scoping out amendments on other issues, is there an issue in terms of scoping out a potential amendment to ensure that it's on the face of the bill and then there's no ambiguity?
Yep.
That's agreed, Chair.
I ask, is there also take into account age, that there may be creditors, so we're not discriminating against age? I think that would be very important too.
Yeah, I think, Chairperson, that was what I took from what the points the members were making there, that it will be, that's who I'm thinking of in my family who were...
So a member content then that we scope out a potential amendment around these issues in the bill office, but also write to the minister to seek her clarity and assurances around these issues.
that agreed?
Could I clarify that there are different types of subordinate legislation, and regulations is one form,
Yes.
but rules are another, a distinct form. So the intention would be that any matters in relation to the notice period would be set out in rules rather than in regulations.
No, and that's a fair point. I
That's a
suppose.
technical distinction.
Yeah, and that's where the important clarification, I suppose, from the Minister. If we haven't obviously seen the rules, so if the Minister can clarify that that will be the case, then
Yes.
that would be important for us. So.
Okay, on
Right.
that basis, we'll move on, if that's agreed. Okay, so clause 8 is abolition of requirements to hold meetings on individual insolvency. It's at page 74 to 77. Deals with the same things. It's deemed consent and physical meetings for individual insolvency, very similar to clause 7. So I'm going to assume, Chairperson, that it's the same answer.
Yes.
Okay, covered, very good. Then clause 9, which is at page 79, is the ability for creditors to opt to not receive certain notices around company insolvency. The clause is described as allowing creditors to opt out of receiving notices from company creditors. Again, something that the department did refer to, and indeed insolvency practitioners did too. Can I ask the department if there's anything to add?
Nothing more to add to that.
And if the members understand the clause?
Yeah.
And if we're then content that because there are no amendments or evidence was provided, are they content to support the proposition that the clause stands part of the bill informally? Great, fab. 10 then. Excuse me. This is the ability for creditors to opt to not receive certain notices around individual insolvency. It's at page 78 to 79. So it is pretty much the same as the previous. Are members therefore content for this to, informally and content for this to stand part of the bill?
Yes.
Okay. Number 11, creditor consent for the purposes of Article 13CB. This is at page 80. The clause is described as supporting clause 7 and the removal of the need to hold physical meetings. I'm going to guess that the same thing is going to apply, that we'll be looking for either an amendment or assurance, possibly both.
Yeah.
So if that's okay, we'll, and yes, we can move on from that one. 12 is clause 12, challenge to director's actions. This is at page 80 as well of the pack. The clause is described as supporting clause 7, the removal of the need to hold physical meetings. A department here, I think, advised of a drafting error. I thought that was 13. Sorry, I think I've got that wrong. It was 13 is the drafting error, isn't it? Again, and because this refers to physical meetings, I think we're probably in the same place, if that is agreed, members?
Yes.
Okay, fab. 13 then, this is about regulated companies and modifications to Part 1A. This is at page 81. The clause is described as supporting clause 7 and the removal of the need to hold physical meetings. So again, I think we're probably there again. That's okay, right. Then we'll move on to 14. Nominees report on company's proposal, 81. Okay, this is also supporting clause 7. Yes, we've said this a few times. So is there anything the department can add around clause 14?
Nothing more to add to that.
Okay, so again, because it's linked to clause 7, either we'll have an amendment which will satisfy, or there will be, there will be assurances from the Minister that will satisfy. So on that basis, we can move on to 15, which is about summoning meetings. Again, it's about physical meetings, so I think the same thing applies. That's agreed. There's nothing else to add. 16, decisions of meetings. Again, this is about the same thing again. And I think I can say that that is the case for all of them until we get to
24.
Yep, 20.
Up to 23.
Yeah, I think it's up to 22.
You're
So if we
right.
can treat them all that way, members, that we will await these. Okay, that's okay. Then we'll take it to clause 23. A report by administrative receiver. It's at page 85. The clause appears to provide supporting clarification in respect of clause 9 and 10 and the provisions relating to opted out creditors. These are the creditors that have opted out of receiving notices. If the department has nothing to add, then I can ask members if they are content for the clause to stand part of the bill.
Yes.
Fab. 24. Committee of Creditors, page 85. Clause appears to again provide supporting clarification in respect of 9.10 and the provision for those opted out creditors. Again, since there's no amendments, can I ask if the committee is content that it stands part of the bill informally?
Yes.
25. Progress report to company. This is at page 85. Clause is linked to clause 34. There's actually nothing in the explanatory and financial memorandum about it, but just ask the department just to tell us what that one's about, clause 25. And it's linked to clause 34, I think.
it provides that only one article is to be present in Article 29. I think that the reason for that is that Article 88 is repealed by the bill.
Article 88 is repealed.
Sorry,
To find the repeal would be...
Actually, members, I think I misspoke there. Clause 25 is in fact, of course, in the explanatory and financial memorandum. I'm wrong. There's some other ones that aren't in there. So I think, as has just been explained, it removes a reference to Article 88 in paragraph 1 of the Article 79 of the Insolvency Order, which is repealed. So it's a tidying up clause. So if members are content, therefore, for the clause to stand part of the bill.
We are.
Fab. 26. Final meeting prior to dissolutions at page 86. The clause appears to do away with the need for a final meeting of creditors and instead requires a report to be sent to the Registrar of Companies. Can I ask if members understand the clause, if they're happy enough for it to stand part of the bill?
Yes.
Fab. Well done. 27. Effective companies insolvency. This is at page 86 to 87. The clause sets out what the liquidator in a member's voluntary liquidation must do on discovering that the company will not be able to pay its debts in full from the start of winding up. Again, if the department has anything to add?
No, again, it's in relation to meetings, so it's consequential to those amendments.
Right, so it's right. I didn't actually realise that. So that's actually clause 27 is therefore related to the calling of meetings. So we'll hold that one until we get a response from the department.
Yeah, it's no longer required. Yeah,
Yep.
that's right.
So 28 then is conversion to creditors voluntary winding up. This is at page 87. The clause refers to the point at which members' voluntary liquidation turns into a creditor's voluntary liquidation when the creditors nominate a liquidator to replace the one who had been acting in the members' voluntary liquidation. So again, if the department has anything to add on that one?
Nothing more
Nope.
than that.
Are members content that it stand part of the bill? We receive no evidence on this one.
Yes, we are.
Agreed. Informally agreed. Very good. 29 is application of Chapter 4, which is page 88. The clause makes amendments to the insolvency order in respect of creditor winding up, replacing member winding up of a company. Again, no evidence or amendments were proposed on this one. Is committee content that it informally stands part of the bill?
Yes.
30. Meeting of creditors is at page 88. This seems to replace Article 84.5 of the Insolvency Order. Again, no clauses or amendments were proposed. Can I ask if the committee is content for it to stand part of the bill? Okay. 31. Director's Statement of Affairs to Creditors. This is at page 88. The clause requires that the directors of a company undergoing winding up still have to prepare a statement of the company's affairs, but they now have to send it to the creditors. They must do this within 7 days from the day after the day in which the resolution to wind up the company was passed. Again, do members have any questions, or do they understand the clause? Or
There were no concerns from evidence raised in that either. So.
Not at all. So are members informally content that it stand part of the bill?
Yes.
32. Appointment of liquidator, page 89. The clause makes provision as to how a liquidator is to be appointed in a creditor's voluntary liquidation, not preceded by a member's voluntary liquidation. Again, no evidence received, no amendments proposed. Are committee informally content that it stand part of the bill?
Yes.
Fab. 33. Appointment of liquidation committee. This is at page 89. The clause amends existing provisions which give the creditors in a creditor's voluntary liquidation the right to appoint a liquidation committee with up to 5 members and the company the right to appoint up to a further 5 members. Again, no evidence received, no amendments proposed. Are the committee informally content that it stands part of the bill?
Yes.
Thank you. Clause 34. Members' creditors' meetings were winding up converted under Article 82 is at page 90. The clause appears to repeal Article 88 of the Insolvency Order. Again, there was no evidence received or amendments proposed. Is the committee informally content that it's stand part of the bill? Okay, yes. Thanks, members. Thank you. 35. This is clause 35, progress report to company and creditors. This is at page 90. The clause appears to alter references to creditors to those which have not opted out. So again, this is what we were told, what the committee was told was that you get creditors who don't really want to receive lots and lots of communications. So there's an option earlier in the bill for them to opt out of this. And this is a lot of tidying up amendments around that. So again, no evidence received, no amendments proposed. Is the committee informally content that it stand part of the bill?
Yes.
Fab. 36, final meeting prior to dissolution is at page 90. The clause dispenses with the former requirement for the liquidator to call meetings of the company and its creditors once a company in a creditor's voluntary liquidation has been fully wound up. Again, no clause, no evidence received, no amendments proposed. So is the committee informally content that it stand part of the bill? Fab. Thank you. Clause 37, powers of directors where no liquidator appointed or nominated by company. This is page 91. Clause provides that the directors of a company which is in voluntary liquidation are not to exercise any of their powers except in certain circumstances. Again, no evidence received, no amendments proposed. Are you content that it stand part of the bill informally?
Yes.
Fab. 38. Functions of official receiver in relation to office of liquidator. This is at page 91. The clause amends amendments to Article 116 of the Insolvency Order to ensure that in a High Court winding up, the choice of a person to replace the official receiver as liquidator is made in ways which do not involve a physical meeting. So again, members, there was no evidence received or amendments proposed. Or is the committee informally content that this stand part of the bill?
Yes.
Okay, fab. Number 39 is appointment by department. So the clause makes amendments to the Insolvency Order such that in a winding up by the High Court, the duty which the official receiver is under to decide whether to refer the need for a person to be appointed to take over from them as liquidator to the department now arises if the creditors and contributories have failed to nominate a person to act as liquidator. Okay, again, there was no evidence received, no amendments were proposed. Is the committee informally content that it stand part of bill?
Yep.
Fab. 40. Choice of liquidator at meetings of creditors and contributories. This is at page 92. The clause amends the Insolvency Order such that provisions now apply where the creditors and contributories of a company being wound up by the High Court are asked to nominate a person to be liquidator. Again, it sounds kind of similar to the previous one, but there was no amendments proposed or evidence received. Are you content that it stands part of the bill?
Yes.
Okay, very good. 41. Appointment of liquidator by High Court following administration or voluntary arrangement. This is at page 93. The clause is described as simplifying the text by which Article 1165A and B of the Insolvency Order are disapplied in cases where administration or company voluntary arrangement ends with the administrator or supervisor of the arrangement being appointed by the High Court as liquidator. Again, these are all sound like tidying up amendments, but no evidence was received, no amendments proposed. Are you content that it, informally content that it stands part of the bill?
Yes.
Thanks, members. Well done. If we're feeling like a break, then do say, because I'm all right.
No, it's
doing well.
early days.
No, we're doing well. We're doing well. Okay, so clause 43, duty to summon final meeting is at page 94. The clause requires the liquidator to prepare an account of the winding up as soon as this appears for practical purposes to be complete, and obliges the liquidator to send a copy of the account and confirmation as to whether any of the creditors objected to his or her release. So again, there were issues which I think we'd heard about the release of liquidators. So when is their job actually done? Again, no evidence received, no amendments proposed. Is the committee informally content that it stands part of bill?
Yes.
44, delegation of High Court's powers to liquidator, page 94. The clause introduces provisions enabling or requiring liquidators acting under control of the High Court to exercise any powers or discharge any duties which the court is under with respect to the seeking of decisions on any matters from creditors and contributories. So again, no evidence received, no amendments were proposed. Are you content that it stands part of bill informally?
Yes.
Fab. 45. This is about liquidators' powers and duties and creditors' voluntary winding up. It's at page 95. The clause sets out what powers a liquidator nominated by a company in a creditor's voluntary liquidation has during the period prior to the creditors either nominating or failing to nominate a person as liquidator. So again, no amendments proposed, no evidence received. Is committee content for this to stand part of bill informally?
Yes.
Fab. 46. The liquidator's supplementary powers. This is at page 95. The clause gives the liquidator the right to seek a decision on any matter from the company's creditors or contributories and obliges him or her to do so if requested by 1/10 in value of either the creditors or contributories. Again, no evidence was received and no amendments were proposed. Is the committee content informally that it stands part of the bill?
Yes.
47. removal of the liquidator, voluntary winding up, and this is at page 96 of your packs. The clause provides that in a creditor's voluntary winding up, the only way in which the liquidator can be removed from office, otherwise than under a High Court order, is by the company's creditors deciding, in a qualifying decision procedure instigated for the purpose of removing the liquidator, that he or she should be removed. Again, no amendments were proposed. Is the committee content for this to, informally content for this to stand part of the bill?
Yes.
Fab. 48, removal of liquidator, winding up by the High Court, is at page 96. This actually looks a bit similar to 47. Again, no amendments or evidence was received. Is the committee informally content for it to stand part of the bill?
Yes.
Thank you. 49. Release of liquidator, voluntary winding up. This is at page 97. The clause introduces new paragraphs setting out the ways in which the liquidator's time in office can end and their release can take place. Again, no evidence received. Is the committee content for the clause informally and content for the clause to stand part of the bill? Thanks, members. 50, doing well. Release of liquidator, winding up by the High Court. This is at page 98 to 99. The clause also deals with the liquidator's release in the case of winding up by the court. Again, no evidence was received. There was no commentary on this and no amendments were proposed. Is the committee informally content that it stands part of the bill?
Yes.
51. Resolutions passed at adjourned meetings is at page 100. The clause appears to repeal Article 163 of the Insolvency Order, which refers to resolutions passed at adjourned meetings. There was no commentary on this and no amendments were proposed. Is the committee informally content that it stand part of the bill? 51, that's 51, very good. Now we're at 52. Meetings to ascertain wishes of creditors or contributories, and this is at page 100. The clause amends the Insolvency Order such that where the High Court makes the creditors and contributories wishes, where the High Court takes the creditors and contributories' wishes into account when dealing with the winding up of a company, the court can direct that qualifying decision and deemed consent procedures are to be used to ascertain those wishes. Again, no commentary on this, no suggested amendments. Is the committee content informally that it stand part of the bill?
Yes.
53, dissolution, voluntary winding up, is at page 100. The clause revises provisions which establish when a company which has been voluntarily wound up is dissolved to include when the final account and statement has been sent to the registrar of companies. Again, no commentary on this. Is the committee informally content that it stand part of bill? Mm-hmm. Clause 54, early dissolution, is at page 101. The clause amends the Insolvency Order to include reference to opted out creditors. So again, these we learned earlier what those were. So no evidence received, no amendments proposed. Is the committee informally content that the clause stand part of the bill? Yes. 55, dissolution in other cases. This is at page 101. This actually seems to be really rather similar to clause 53. Can I ask if the member is if the committee is informally content for the clause to stand part of the bill?
We are.
Yeah.
Very good. 56, misconduct in the course of winding up, and this is at page 102. This amends the Insolvency Order to refer to qualifying decisions or deemed consent procedure. Again, no evidence, no amendments proposed. Is the committee informally content that it stand part of the bill?
Yes.
57, protection of supplies of goods and services is page 102. So the Insolvency Order renders void clauses in contracts for the supply of goods and services which either provide for automatic termination of the contract or supply, or which permit the supplier to terminate the contract or supply in the event of a company entering any of a range of relevant insolvency procedures. So what the new clause does, it provides that the insolvency period ends when the liquidator complies with certain conditions. So again, there was no commentary on this, no amendments were proposed. And if the department has nothing to add, then can I ask, is the committee informally content that it stand part of the bill?
Yes.
So clause 58, penalties for offences under the 1989 order is at page 102. This amends the penalties for offences to level 3. Again, there were no amendments proposed, no evidence provided. Is the committee informally content that it stand part of the bill?
Yes.
59. Definition of the relevant date is at page 103. This amends Article 3472 to alter the wording in respect of relevant date consideration. I think I'm right in saying there's actually nothing in the, am I right in saying, yeah, this doesn't actually appear in the explanatory financial memorandum. Could I just ask the department, could they explain what the relevant date is?
Well, the Jack, can you take that one?
I would have to look at Article 347 to give you an answer to that.
Just it isn't in the explanatory and financial memorandum, members, so it's just.
And it's paragraph 2 says, for the purposes of Article 17, meetings to consider company voluntary arrangement. Well, that relates to where a scheme to address a company's insolvency has been put forward for consideration to allow, it would usually be, the company's debts to be paid over a period of time. And previously, the creditors would have been asked to vote at a meeting on whether or not to approve the proposal which was being put forward. That, of course, would no longer be appropriate given the policy of doing away with meetings. So, therefore, the use of the word meetings in paragraph 2 would not be appropriate, and that is why it has had to be changed to consideration by the company's creditors.
Members are content with the clause that's on part of the bill? Thanks for that. Okay. Clause 60 then. Sorry. Clause 60, admissibility of evidence in statement of affairs, etc. is at page 103. Paragraph 2 of Article 375 of the Insolvency Order restricts the use which can be made of certain statements in criminal proceedings. Paragraph 3A of Article 375 disapplies paragraph 2 in the case of offences under listed articles in the Insolvency Order. So what clause 60 does, it removes from this list a reference to Article 84.5, which is repealed by clause 30. So again, this is a tidying up amendment. So no amendments or proposals around this have been received. Is the committee informally content that it stand part of bill? Yes. Thank you. Clause 61. Representation of corporations at meetings is at page 103. Paragraph 1 of Article 384 of the Insolvency Order made provision about how a corporation, which was a creditor or debenture holder of a company, could be represented at meetings with the company's creditors. Clause 61 replaces paragraph 1A of Article 384, referring instead to representation in the qualifying decision procedure by which a decision is sought from the creditors of a company. Again, no commentary was received on this. Our committee informally content this would stand part of the bill?
Yes.
Well done. 62, provision that may be included in company insolvency rules is at page 103 to 104. Clause 62 amends Schedule 5 to the Insolvency Order, which sets out provisions which can be included in company insolvency rules, including the appointment of a liquidator and the establishment of a creditor committee, which we've heard about in earlier clauses. Again, there were no commentary on this. Is the committee informally content that it stand part of bill?
Yes.
63. This is the nominees' report on debtors' proposals. It's at page 104. So Article 230 of the Insolvency Order applies where a debtor who intends to put a proposal for a voluntary arrangement to their creditors has obtained an interim order from the High Court giving them temporary protection against bankruptcy and other proceedings. Article 230 obliges the nominee to submit a report to the High Court during the interim order period, which includes an opinion on the prospects of success for the voluntary arrangement which the debtor is proposing. Clause 63 removes all references in Article 230 to consideration by the creditors taking place at a meeting. So again, this is going to be by this deemed consent approach as well. So if there's no commentary on this, the committee content that this stand part of the bill informally. Yes. Fab. 64. Debtors' proposal and nominees' report is at page 104. Article 230A of the Insolvency Order applies in cases where a debtor who intends to put a proposal for a voluntary arrangement to his creditors has not obtained an interim order. When making a report to the creditors, the nominee has to include an opinion on the prospects for success of the voluntary arrangement which the debtor is proposing. Clause 64 amends paragraph 3 of Article 230A so that it no longer refers to consideration by the creditors taking place at a meeting. Again, it's back to the deemed consent thing again. So our committee informally content that it's stand part of the bill? Yes, thank you. 65, creditors' meetings at page 105. Clause 65 amends Articles 231 of the Insolvency Order, which establishes the procedure to be used by the creditors to reach a decision on whether to approve a proposal for a voluntary arrangement. Clause 65 allows the creditors to make the decision using a creditor's decision procedure, presumably rather than a physical meeting. So again, this isn't about the digital thing, this is about the deemed consent part. So if members are content that this stand part of the bill? Thank you. Clause 66, decisions of creditors' meetings at page 103. Again, this removes the reference to physical meetings, as is the case with clause 65. Again, are members informally content that it stand part of the bill?
Yeah.
67, report of decisions to High Court is at page 106. Clause 67 amends Article 233 of the Insolvency Order, which makes provisions about who the creditor's decisions is to be communicated to. Clause 67 provides that the nominee must first report the creditor's decision to the High Court and then give notice of it to such persons as may be prescribed. Again, no commentary, no amendments received. Is the committee informally content that it stand part of the bill?
Yes.
Yeah.
Then we have 68, effective approval. This is at page 106. Article 234 of the Insolvency Order establishes when an approved voluntary arrangement takes effect and sets out the consequences for creditors of its being approved. Clause 68 amends Article 234 to reflect that approval is now by means of a creditor's decision procedure instead of a meeting. So again, no commentary was received on this. Is the committee informally content that it stand part of bill?
Yes.
Thank you. 69, additional effect on undischarged bankrupt is at page 106. Article 235 of the Insolvency Order applies where a voluntary arrangement has been approved and the debtor is an undischarged bankrupt. Under Article 235, application can be made to the High Court to have the bankruptcy order annulled. Clause 69 amends Article 235 to reflect that approval is now by means of a creditor's decision procedure instead of a meeting. So, same thing again. Is the committee informally content that it stand part of bill?
Yes.
Well done. 70, challenge of meetings decision, page 107. Article 236 of the Insolvency Order gives the debtor, the creditors and certain other interested parties the right, within specified time limits, to apply to the High Court for redress if they consider that there has been material irregularity in the procedure used to seek the approval of creditors to a proposal for a voluntary arrangement. Clause 70 amends Article 236 to reflect that approval is now by means of a creditor's decision instead of by a meeting. Again, there was no commentary received. Is the committee informally content that it stand part of bill?
Yes.
71. Prosecution of delinquent debtors. This is page 107. Article 236B of the Insolvency Order sets out what action a nominee or supervisor is required to take on discovering that a debtor appears to have been guilty of a criminal offence in connection with a voluntary arrangement which has taken effect following approval by the creditors. Clause 71 amends Article 236B so that it now refers to approval by a decision of the debtor's creditors instead of by a creditor's meeting. So again, deemed consent, etc. So is the committee content that this stand part of bill?
Yeah.
72, arrangements coming to an end prematurely, and this is at page 108. Article 236C of the Insolvency Order establishes the circumstances in which a voluntary arrangement is to be treated as having ended prematurely. Clause 72 amends that article so that it now refers to approval by a decision of the debtor's creditors instead of a creditor's meeting. So again, members, are you informally content that it stand part of bill?
Yes.
Thanks, very good. 73, implementation and supervision of approved voluntary arrangement. This is at page 108. Article 237 of the Insolvency Order provides that once a voluntary arrangement takes effect, the nominee is to become known as the supervisor and sets out what interventions can be made by the High Court. Clause 73 amends Article 237 so that it now refers to approval by a decision of the debtor's creditors instead of by a creditor's meeting. So again, members, are you content informally that it stands part of the bill?
Yes.
Thank you. 74, definition of a bankrupt's estate is at page 108. The clause amends a bankrupt's right to exercise power over property which does not form part of their estate, such that it is not to be treated as the bankrupt's property if the trustee in bankruptcy has vacated office by giving notice to the High Court and creditors that their administration of the bankrupt's estate is complete. Again, there was no commentary on this one. Do members require clarification?
Yeah, can you clarify what that means in practice, really? So this is about the property or somebody's own personal property? Yeah.
The bankrupt's estate is any assets they have, but that the estate is defined as excluding as household furniture and tools and equipment for use in their business. Or a business carried on by the bankrupt personally.
Is this the one where the spouse? No, this is not the same.
No.
No, so no, then that's fine. That's
Okay.
You're referring, I think, to clause 85.
85.
Yes.
Just happened to look at it just
There
a
you
second.
go. There you go. See, remember,
Very
definitely.
clever.
There's one a couple on. Is there?
Yes, yeah, I know they do all sound very similar.
There's
but
one in 76, I think, or around
No,
that.
no, it's right to ask.
Yeah.
It's right to ask.
Absolutely right.
Yeah.
And yeah, 85 is the bankrupt's home.
Yeah.
I think where the numbers where that intersects. So, clause 74. The committee, therefore, at this point, informally content that it stand part of bill.
Yeah.
Great, thank you. Very good. 75. Default in connection with voluntary arrangement is at page 109. Clause 75 makes amendments to the insolvency order such that a bankruptcy order can be made if information made available by the debtor to their creditor in connection with the creditor's decision procedure is discovered to have been materially false or misleading. Again, there were no information or amendments proposed on this one. Is the committee informally content that it stand part of bill?
Yes.
76. Powers of interim receiver is at page 110. The clause gives an interim receiver appointed to safeguard a debtor's property the right to seek a decision on any matter from the debtor's creditors and place the receiver under a duty to do so if directed by the High Court. The bar made some suggestions around the court's discretion to appoint receivers. I think we might sort of pick this up again under clause 92. But other than that, is the committee content at this point, informally content that it stand part of bill? Okay,
Yes.
very good. 77. Appointment of trustees by department. This is at page 111. A person who is appointed by the department as trustee of a bankrupt's estate has to either give notice to the creditors of their appointment, or if the High Court allows it, advertise their appointment in accordance with the court's directions. Following the amendment made by clause 77, the notice or advertisement must include an explanation of how to establish a creditors committee. So again, there were no amendments proposed on this one. Is the committee content informally that it stand part of bill?
Yeah.
78. Trustees' vacation of office at page 111. Article 271 of the Insolvency Order makes provision as to how a trustee in bankruptcy can be removed from office, how they can resign, and when they can vacate office. Okay, so we're still core 8, we're okay.
Yes.
Yeah.
So, where was I? Following clause 78, Article 271 will now list the circumstances in which a creditor's decision procedure can be instigated for the purpose of removing the official receiver from the office of trustee if he or she occupies that office by reason of having been automatically appointed to it on the making of a bankruptcy order, or removing from office a trustee who has been appointed by the department or the High Court. Again, there was no commentary on this. Is the committee informally content that it stand part of bill?
Yes.
79. Release of trustees is at page 112. Clause 79 amends Article 272 of the Insolvency Order, which makes provision about release both of the official receiver when acting as trustee and of insolvency practitioner trustees. Again, there was no commentary on this one. If members are informally content for it to stand part of bill. Very good. Clause 80. Vacancy in Office of Trustees at page 113. Article 273 of the Insolvency Order establishes that in the event of the office of a trustee of a bankrupt estate becoming vacant, the official receiver becomes trustee and sets out actions which the official receiver can take or is required to take to have the vacancy filled. Clause 80 makes a number of changes, including giving the official receiver the right to ask the creditors to appoint an insolvency practitioner as trustee and obliging the official receiver to do so if a minimum of 1/10 in value of the creditors request it. Again, no commentary on this. Is the committee informally content that it stand part of the bill?
Yes.
81. Creditors Committee. This is at page 114. Article 274 of the Insolvency Order gives a bankrupt's creditors the right to establish a creditors committee. Clause 81 amends 274 to remove all reference to this being done in a general meeting. Again, no commentary on this has been received. Is committee informally content that that stand part of bill?
Yeah.
Thank you. 82. Are we here yet? No, we're not. Trustees' powers is at page 114. Clause 82 gives a trustee in bankruptcy the right to seek a decision on any matter from the creditors and obliges a trustee to seek a decision on a matter if a creditor requests it, and a minimum of 1/10 in value of the creditors wanted done. So, again, there's no commentary on this. Is the committee informally content that it stand part of bill?
Yes.
83. Final distribution, page 114. The clause amends Article 303 of the Insolvency Order such that notices need not be provided to opted-out creditors. These are the creditors who've decided don't want to receive any more notices. Again, there was no amendments or information received on this clause. Is the committee informally content that it stand part of bill?
Yeah.
84. Final meetings at page 115. Clause 84 makes amendments to Article 304 of the Insolvency Order, which sets out the action to be taken by an insolvency practitioner trustee once it appears that the administration of a bankrupt estate is, for practical purposes, complete. There were no comments on this one, and no amendments were proposed. Is the committee informally content that it's not part of the bill?
Yes.
85, Bankrupt's Home. This is at page 116. Clause 85 amends Article 305 of the Insolvency Order, which applies where a bankrupt's estate includes an interest in property which the trustee has not been able to realise. Clause 85 amends paragraph 2 of Article 305 with the effect that it now prevents the trustee issuing a notice to creditors that administration of the bankrupt's estate is for practical purposes complete unless certain actions have been taken by the High Court or the Department. The Bar of Northern Ireland made reference to differences between Northern Ireland and England and Wales in respect of the assessment of the rights to the family home of the non-bankrupt spouse. The Department had argued that related amendments would have far-reaching consequences well beyond the scope of the bill. I think.
Yes, Mr. Honeyford.
I suppose it's the difference between the law we're not following England and why I suppose does the department accept the concern from the bar here that we're not actually following England and Wales, we don't have those full protections, that the family home is still, there's protection still around the spouse?
I just have a look at Article 305 and the alteration which will be made to it.
I think this alteration just really refers to the fact that these matters will not be dealt with at a meeting, so it's quite in terms of the bill. I think what the bar was bringing in was like the wider considerations around the protections which wouldn't necessarily be within the scope of the bill. Jack, do you want to?
305(2). Oh yes, that's exactly the reason for the alteration I previously referred to. When the trustee was able to summon a meeting under Article 304, which is a final meeting of the creditors to lay his report before them to explain what had been carried out in the course of the administration of the bankruptcy. So in keeping with the policy that physical meetings are done away with, it would be inappropriate for paragraph 2 to refer to a meeting being summoned under Article 304, and therefore it needs to be changed to the wording needs to be changed so it refers to giving notice under the previous article, that is Article 304. So it doesn't alter the safeguards for the bankrupt spouse or their children in any way. It simply deals with a requirement which the trustee is under at the conclusion of his administration of the estate.
So what's the purpose? So the purpose is to do what? So the bar are saying that we're not following England and Wales here and the wider powers around it, and then you're saying it's out of scope. But what's the purpose of this is just to do. So what protections are there then? Or is that outside?
Well, I can neither confirm nor deny that this amendment is not in keeping with England and Wales, because I don't have a copy of their Insolvency Act 1986 in front of me. I would believe that it would be the same as that the same amendment would have been made to the equivalent provision in England and Wales, but I would have to check that in the 86 Act.
Yeah. Can we check that just?
I think we're talking about a different. So clause 85, we're referring to, not clause 84. Yeah.
85. Yeah.
85.
But
Yes.
I think what it's
That's the amendment
Yes.
to Article, but it amends Article 305.
Yeah, but I think the point the member's making, keep me right here, is it isn't what clause 85 does. It's a wider point he's making about the bankrupt's home, that in Northern Ireland you're more likely to lose your home than you are in England and Wales. So although that's not what the clause does, it does open the Pandora's box of the bankrupt's home, and that's where the committee would be possibly seeking an amendment. And what they're looking for from the department now is to clarify, why are we different in respect of why are we more likely to lose our homes in Northern Ireland than we would be in England and Wales? And why would you not want to amend in order to bring us into line with England and Wales?
Well, that really is a wider issue which is outside the scope of the bill. This aspect of the bill deals with consequential amendments which are required as a result of the changeover from physical meetings to using virtual means to communicate. It doesn't address the issue of safeguarding the interests of spouses or other dependents in the bankrupt's home, whereas there is a threat of them losing it as a consequence of the person's bankruptcy. We didn't address. That wasn't the purpose of the bill, to put in place measures to put in place additional safeguards for spouses and dependents in those circumstances. I know that this issue has been raised of bankrupts or families being more likely to lose their homes in Northern Ireland. The same protections would apply under human rights to a person's right to enjoy their property in Northern Ireland as it does in the rest of the United Kingdom. I think that would be the policies of the courts rather than a difference in legislation. Offhand, I don't think that they're... without studying the issue in depth, I can't comment on whether... I can't confirm that there's no difference in the legislation in the two jurisdictions, but I don't think that there is. I think it would be a matter of how that application is applied by the courts.
Yeah. I suppose the bar and their evidence have said that there are differences. That's the evidence that they provided to the committee.
Yeah.
And I suppose when we were looking at this, and Mr. Honeyford has raised some of the concerns and the fact that that differentiation is there. And I know what you said in terms of the feeling of the department in terms of that within the scope, but surely this is something which should very much be addressed. And that's why we had certainly as a committee discussed scoping out a potential amendment to try and ensure that people in Northern Ireland are not more vulnerable to losing their homes in comparison with their counterparts in England and Wales. Is that fair?
That's exactly summed up, yeah.
So, Chair, to take it...
Here, I'm not sure that I have the bars. Was this in the bars presentation or the letter which they sent to the committee?
It was.
Well, they did do a physical, I don't know if it was physical, but certainly it was virtual, but there was a presentation and evidence, and also they had a written submission, is that right?
They did. I think, Chairman, might I suggest to move it on, what the committee might do, it sounds like you're agreed, we'll write to the department about this issue, and also I will ask the Bill Office to scope out a possible amendment to see if it's what they think of it, and then we can, I think I would be conscious this is quite involved and it might be hard for the department to answer today, so we'll write to you, and then before we get the formal clause by clause, hopefully you'll come back to us with why you think it can't be done, and I'll also speak to Bill Office and see why they think it can be done, and then the committee can decide how to take it forward, if that's okay.
The difficulty we have is we would be introducing really a completely new policy element at this late stage, which hadn't been addressed at all in the bill, and it hadn't been the intention is to really bring in, for the benefit of the insolvency profession here, provision equivalent to what had been made by three acts made at Westminster. And there would be a lot of procedure involved in doing that, particularly consultation, also preparation of a regulatory impact assessment, equality screening, all that type of thing, really the same sequence of things which has to be done if you're taking a bill forward from scratch. And to start that at this stage, given the remaining lifetime that's left in the mandate, it could be difficult.
This is the first time we've had the chance to actually put stuff out. This is the first time we've had an opportunity. So we're not in a late stage. We're at the very start of the process, and we're flagging it at the very start of the process. The service of what you've done so far has been great at bringing us through, but we're flagging this, and I couldn't care less. It was 18 months left in the mandate. Yeah. We will do what the committee will do to scrutinise the legislation that's in front of us. Otherwise, it's absolutely pointless us sitting going through 100 and...
Yeah, of course, and I don't know, and I share that sentiment, and I suppose for ourselves, you're right, Dave, this is our first opportunity in terms of this informal discussion, and a lot of this bill is obviously lifted from England and Wales and a lot of the learning, and it's a right question to ask in terms of why in this particular issue should we not now address it.
Sure.
rather than, as David says, put something through that isn't actually going to address all of the concerns. So I think that, Clerk, to move things on,
Yep.
I think your proposal is
Second that 100%.
and David and the members are happy that we write to the department, get that clarity, and in tandem we get a proposal or a scoping exercise from the Bill's office to see what can be done potentially. Content?
Marvellous, thanks members. So moving on then to clause 86, the offence of making false statements. This is page 117. Clause 86 amends paragraph 3C in article 327 of the Insolvency Order. The amended provision makes it an offence for someone who is later made bankrupt to have attempted to account for the loss of property by fictitious losses or expenses. Again, we received no commentary on this one. Is the committee informally content that it stand part of bill?
Yes.
Thank you. Still that. Clause 87, a provision that may be included in individual insolvency rules at page 117. Clause 87 amends Schedule 6 to the Insolvency Order, which sets out provision which can be included in individual insolvency rules. Again, there was no commentary on this one. Are committee content that it's not part of bill informally? Yep. 88. Extension of Administrator's term of office is at page 117. Clause 88 amends Schedule B1 to the Insolvency Order so as to increase the maximum period for which it is possible for the administration to be extended with the consent of the creditors from 6 months to 1 year. Again, no comments received. Is committee informally content? Yes. Very good.
You're okay?
I'm okay, yeah, I'm grand, yeah. Well, if you can listen to me, I can go on. So, Clause 89, Administration, payments to unsecured creditors is at page 118. Clause 89 amends Schedule B1 to the Insolvency Order to establish that an administrator can make a payment out of the prescribed part of a company's property without seeking the High Court's permission, and that the fact that the administrator thinks that the company is in a position to make such a payment does not trigger the option of moving to a creditor's voluntary liquidation. Again, no commentary on this one. Is the committee informally content that it stands part of bill?
Yes.
Clause 90. Creditors not required to prove small debts. Company insolvency is at page 119. Clause 90 inserts a new paragraph 13A into the Schedule 5 of the Insolvency Order, which will enable provisions to be included in company insolvency rules to permit the payment of dividends to creditors who are owed less than a prescribed amount without the creditor having to submit a claim. The intention is to set this amount initially at £1,000. As there, again, no commentary was received on this. Is the committee content informally for this to stand part of the bill?
Yeah.
Thank you. 91. Creditors not required, clause 91, creditors not required to approve small debts, individual insolvency is at page 119. Clause 91 inserts a new paragraph 16A into Schedule 6 of the Insolvency Order. This will enable provision to be included in individual insolvency rules to permit the payment of dividends to a bankrupt's creditors if they are owed less than a prescribed amount without the creditor having to submit a claim. The intention is to set this amount initially at £1,000. Again, no commentary was received on this. Is the committee informally content for this to stand part of bill?
Yeah.
92. Right. Trustees and bankruptcies is at page 120. Now, the Insolvency Order currently provides that when the High Court makes a bankruptcy order, the official receiver automatically becomes receiver and manager of the bankrupt's estate, unless, as can happen only in certain special cases, the court appoints an insolvency practitioner as trustee. This means that until such time as a trustee is appointed, the official receiver's role is limited to protecting the estate. The Department advises that the initial appointment of the official receiver as receiver and manager has not been shown to have any practical benefit for the administration of bankruptcy cases and serves to delay the realisation of assets. Clause 92 therefore inserts a new Article 264A into the Insolvency Order, which provides for the official receiver to instead become a trustee on the making of a bankruptcy order, unless the court appoints someone else. The Bar of Northern Ireland suggested that the provisions relating to the immediate appointment of the official receiver should be amended to indicate that these will not override the court's power to appoint another insolvency practitioner in exceptional cases. The Department countered that the court has general powers of administration and superintendence, and it can appoint receivers whenever it likes, and nothing in the bill undermines this. So our members therefore, based on the balance of all that, content to support the proposition that the clause stands part of the bill informally. Marvellous. 93. Abolition of fast-tracked voluntary arrangements, page 121. Fast-track voluntary arrangements are a streamlined individual voluntary arrangement, an IVA, procedure for cases where a debtor has already been made bankrupt. These were introduced in March 2006 and have never been used in Northern Ireland. Is the committee content for this clause to stand part of bill?
Yes.
Okay, clause 94, power to add to supplies protected under the 1989 order. This is at page 121. Okay, the clause gives the department power to make regulations amending Article 197 of the Insolvency Order. This article currently allows utility suppliers to seek a personal guarantee from the insolvency office holder before continuing to supply an insolvent company, and prevents such suppliers insisting on pre-insolvency arrears being cleared as a condition of continuing supply. The clause widens the scope of utility suppliers to include IT supplies. So again, there was no comment or amendment on this. I think this is about companies which are on the brink being allowed to continue to trade is the idea, and IT would be a key supply. So is the committee informally content for the clause to stand part of bill?
Yes.
95. Power to give further protection to essential supplies at page 122. This clause gives the department power to make regulations that, provided any conditions specified in the regulations are met, it will render void certain contractual terms in contracts for the supply of essential goods or services which would otherwise be triggered by a company going into administration. The supplies that may be protected are supplies of gas, electricity, water, communications and IT supplies. So not dissimilar to the previous. As the committee therefore informally content that it stand part of bill. Okay, 96. Protection of supplies of water, electricity, etc. is page 123. Clause 96. Okay, this appears to be pretty much the same as 94, I think. But this applies where an individual has been carrying on business in their own right or was a member of a partnership, etc. So again, there were no commentary on this. Is the committee content that it stand part of bill? Informally, thank you. 97. Further protection of essential supplies at 124. The clause applies where a voluntary arrangement proposed by an individual who's been carrying on a business in their own right or as a member of the partnership is approved. Article 343A provides that on this happening, any insolvency related terms in the contract of supply to the business of utility or other goods ceases to have effect. The effect is to prevent the supplier causing or permitting the termination of the supply or the contract, altering the contract terms, or demanding increased payments for the supply. And this appears to be some of those previous clauses, but quite similar to those. So is committee content informally that it stand part of bill? Thank you. 98. Clause to add supplies protected under the 1989 order is at page 124. This appears to replicate clause 94, except it's for individuals trading, and it adds to the list of essential supplies. So again, as there has been no commentary, is the committee informally content that it stand part of bill? Thank you. 98. 99. Power to give protection to essential supplies of 125. This appears to replicate clause 95 again, except for individuals trading. Again, can I ask members if they are informally content that it stand part of bill?
Yes.
Very good. Clause 100. Sections 94 to 99, supplemental, is at page 126. These are regulation making powers and are subject to draft affirmative resolution. Are members informally content that this stand part of bill?
Yes.
Okay. 101, remote attendance at meetings and use of websites. Clause 101 inserts new articles into the insolvency order. These new articles allow meetings of company members to be held in company insolvency proceedings without the participants having to be present at a single physical location. Clauses 7 and 8 also refer. There was commentary from the Bar of NI about this. What I would suggest we do with this one, members, is that we treat it as we had with the others, and we'll wait for these various responses and possible amendments. That's okay if members agreed.
Yes.
Thank you. 102, miscellaneous provisions about insolvency law, page 130. Clause 102 introduces Schedule 3, which makes miscellaneous amendments to the insolvency and disqualification orders and other legislation. There's no commentary on this one. Are members informally content that it stand part of bill?
Yeah.
Thank you. 103, notice of proposed resolution for winding up is at page 130. Article 70 of the Insolvency Order makes provision about when a company can be wound up voluntarily, and the procedure must be carried out before a resolution to wind a company up voluntarily can be passed. Clause 103 amends this to include reference to the enforcement of judgment offices. So, again, members, there's no commentary on this one. Are you informally content that it stand part of bill?
Yeah.
104. Notice a result of resolution to wind up voluntarily is at page 131. Article 71 of the Insolvency Order sets out action to be taken by a company once a resolution to wind it up voluntarily has been passed. Clause 104 amends Article 71 so that it now provides that on a resolution for voluntary winding up being passed, notice has to be given within 14 days to the Enforcement of Judgment Office as well as in the Belfast Gazette. Again, there was no commentary on this one. Are members informally content that it stand part of bill?
Yes.
105. Presentation of bankruptcy petitions. Conditions to be satisfied, and this is at page 131. The clause amends the conditions before a bankruptcy petition can be presented to the High Court by an individual's creditors. This will mean that for the test to be passed, rather than the debtor simply being present in Northern Ireland, they'll have to either be domiciled in Northern Ireland or at any time during the 3 years, have been ordinarily resident in Northern Ireland and had a place of residence in Northern Ireland or carried out business in Northern Ireland. Again, there was no clause or there was no commentary or amendments proposed. Is the committee informally content that this stand part of bill?
Yeah.
106, orders relating to recognised professional bodies to be subject to negative resolution. This is at 132. Again, this is a regulation making power. Are members informally content that it stand part of bill?
Yes.
Thank you. Clause 107, amendments to the 1995 order. This is at page 132. Clause 107 sets out transitional provisions for amendments made to the Insolvent Partnerships Order, Northern Ireland, 1985, by Part 12 of the bill. No amendments have been proposed. Is the committee informally content that it stand part of bill?
Yeah.
Thank you. 108, voluntary arrangements of insolvency partnerships. This is at page 132. This appears to alter Article 4 of the Insolvent Partnerships Order to include references to opted-out creditors and the use of qualifying decisions, which we've heard a bit about there. So, again, no amendments proposed. Is the committee informally content that it stand part of bill?
Yes.
Nearly there. 109, voluntary arrangements of members of insolvent partnerships, page 133. Article 5 of the Insolvent Partnerships Order, Northern Ireland, applies where a winding up order is made in respect of an insolvent partnership and a winding up order is made against a corporate member or a bankruptcy order against an individual member. The clause includes reference to deemed consent and qualifying decisions. Again, there's no commentary on this one. Is the committee informally content that it's stand part of bill?
Yeah.
110, administration in relation to insolvent partnerships is at page 134. Article 6 of the Insolvent Partnerships Order, Northern Ireland 1985, applies to the provisions in the insolvency order pertaining to administration to insolvent partnerships. Clause 1110 adds reference to the treatment of opted-out creditors. Again, can I ask members if they're content that the clause informally stands part of bill?
Yes.
111, creditors winding up, no concurrent petitions against member. This is at page 134. Article 7 of the Insolvent Partnerships Order provides that Part 6 of the Insolvency Order is to apply where insolvent partnership is being wound up as an unregistered company on the petition of various listed parties. Among the parties listed is the supervisor of a voluntary arrangement entered into by a member of the partnership. Clause 111 adds to the list the supervisor of a voluntary arrangement entered into by the partnership itself. Again, there was no commentary on this one. Are members informally content that it stands part of bill?
Yes.
112, creditors winding up concurrent petition against member or members. This is page 135. Article 8 of the Insolvent Partnerships Order applies where insolvent partnership is wound up as an unregistered company and a petition is presented to have one or more corporate members wound up or to have one or more individual members made bankrupt. The clause inserts reference to the treatment of opted-out creditors. Again, there's no commentary in this. Are members informally content that it stands part of bill?
Yes.
Thank you. 113. Members winding up concurrent petitions against all members. This is at page 135 to 136. Article 10 of the Insolvent Partnerships Order applies where a member of an insolvent partnership presents a petition to have the partnership wind up as an unregistered company and have all of its members wind up or made bankrupt. Again, the clause inserts reference to opted-out creditors. Again, are the committee informally content that it stand part of bill?
Yes.
Thank you. 114. Individual members presenting joint petitions. No winding up of partnership. Article 11 of the Insolvent Partnership Order applies where the members of an insolvent partnership are all individuals and they all petition to be made bankrupt and to have the partnership wind up, but not as an unregistered company. Again, the clause inserts reference to the opted-out creditors. Are members informally content that this stand part of the bill?
Yeah.
Thank you. 115. Application of the Company Director's Disqualification Order, page 136. Clause 115 sets out the provisions in the disqualification order which apply if an insolvent partnership is wound up as an unregistered company, enters administration, or is wound up otherwise than as an unregistered company. Again, there was no commentary, no amendments proposed. Is the committee informally content that it stand part of bill?
Yes.
116, supplemental and transitional provisions, 137. This appears to introduce just minor wording changes. Again, there was no commentary on this devil. Or members content that it informally content that it stand part of bill. Thank you. 117, amendments to the schedule to the 1995 order. We're at page 137. Clause 117 introduces Schedule 4 to the bill, which makes amendments to Schedules 1 to 10 of the Insolvent Partnerships Order, Northern Ireland 1995. No amendments were proposed, no evidence was received. Is the committee informally content that it stand part of bill? 118, interpretation, page 137, and includes minor clarifications on interpretation. Again, there was no amendments or evidence received. Is the informally content that it stand part of bill? Okay, 119, power to make consequential amendments, repeals and revocations. We're at page 138. So this is another regulation making power. The Department advised, in order to ensure that clause 1193 applies comprehensively to all forms of primary legislation, including Westminster legislation, an amendment will be brought forward by the Department at consideration or further consideration stage. So if members therefore content that subject to that amendment, they are informally content that the amended clause stands part of the bill. Agreed?
Yes.
Thank you. 120, commencement. This commences provisions at part 9, protection of essential essential supplies. So the bit about the electricity and the gas and the IT, that will all be commenced after royal assent. Everything else will be commenced when the department chooses. Now, presumably this is to give the department time to bring forward the regulations and the rules. Again, there's no commentary on this one. Is the committee informally content that it's not part of bill?
Yeah.
121, short title. Is the committee informally content that this clause is part of the bill?
Yes.
Stands part of the bill. Schedule 1, amendments to the Schedule B1 of the 1989 order, etc. And this is at page 139. So clauses 11 to 20, 21 in Schedule 1 and clauses 22 to 24 all make amendments to provisions in the insolvency order which are needed to apply the policy underpinning clauses 7 to 10. And this deals with the holding creditor meetings. Okay, I think this is probably linked to the other thing, to the virtual meetings. So I think subject to the answers that we're awaiting from the department and the business office, I think the members content to hold this for now and come back on that one. Thank you. Schedule 2, trustees in bankruptcy, consequential, page 139. This appears to be a long list of minor amendments relating to bankruptcy provisions. Is the committee content that the schedule, informally content that the schedule stands part of the bill? Thank you. Schedule 3 is at page 140. This is 5 parts. Administration of companies, winding up of companies, disqualification of creditors, bankruptcy and other minor amendments. In respect of part 3, which was disqualification of unfit directors of insolvent companies, the bar suggested that the provisions relating to the immediate appointment of the official receiver should be amended to indicate that these do not override the court's power to appoint another insolvency practitioner in exceptional cases. However, as we've already heard, and this was discussed under clause 92, the department countered that the court has lots of general powers of administrative and superintendents and won't be scared to do whatever it needs to do. So that being the case, is the committee content that the clause stand part of bill?
Yes.
Nearly there. Schedule 4, insolvent partnerships, amendment to schedules. This is page 146. On deemed consent, the Bar of Northern Ireland suggested that the bill provided an unnecessary level of additional discretion to insolvency practitioners. However, the insolvency practitioners disputed this and argued that the deemed consent principle in the bill provides insolvency professionals with a necessary level of the discretion to call creditors meetings if required, and in any event it was argued that creditors could seek a physical meeting, etc. And that the deemed consent principle was argued to be an alternative to the default physical meeting of creditors and could provide a lower cost option. Additionally, Article 23.4 mentioned in the schedule requires that regulations need only be laid in the Assembly and would not be subject to any form of Assembly resolution. It had been suggested that maybe this should be done to negative resolution. However, the department came back and said this might not be very logical, and that because it was so narrowly drawn, I think maybe the feeling was that no further amendment would be required. So that being the case, members, is the committee informally content that Schedule 4 is content that is okay as is and can stand part of the bill?
The insolvency practitioners were content.
Yes, very much so. Yes, they love the deemed consent, and will be calling for this kind of thing for years.
Okay. Yeah.
So other matters then, members. This is page 151. Okay. The Bar of Northern Ireland advised that under the current practice in Northern Ireland, a petition for insolvency will not be entertained unless the creditor has first obtained a judgment, even if the creditor's claim is entirely unopposed. The department indicated this was the subject of a practice direction issued by a High Court Master, and therefore they did not wish to amend. But I I think perhaps Chairperson, the committee, I think, may be minded to ask the Bill Office to explore the possibility of an amendment in this regard, so that that petitions for insolvency could be entertained, as is the case in England and Wales, without a judgment, particularly where the claim is entirely unopposed. So is that where, Chairperson, can I ask where the committee are with this one?
That's where, yeah, our members are content with that. We approach the Bill's Office to scope out the potential amendment. Yeah.
Okay, that's fab. Finally then, the Bar of Northern Ireland also commented on post-petition transactions. So as explained, these are transactions, this is a transfer of property that occurs after the commencement of the bankruptcy case. Such transactions must be validated by the court. These are all done in the High Court in Northern Ireland, but in other jurisdictions it's otherwise. I think in follow-up correspondence, the Bar seemed to clarify its position, indicating that it was content with current arrangements. So can I ask, Chairperson, given that, is the committee therefore content to let this one lie and not pursue it as an amendment at this point?
Yeah.
Agreed?
Yeah.
Done.
Well done, Peter, for getting us through that, and thanks to Jack and Richard as well. Obviously, I don't want anybody despairing, because we do have the opportunity to go through it again on the 19th of November. So do not be disappointed. Thank you, Peter, for that. I don't know, in terms of summary, we have it well summarised in terms of those actions, but do you want to summarise anything further?
Just in terms, because we've done very well today and got through it all, so we won't deal with it next week. When we meet again on the 26th of November, I'll group the clauses, so we won't have to go through them all, because there's like about 9 parts there. So it'll be, the chair will put 9 questions, so it won't be 130 questions. It'll be 9 questions. And again, if members have a brainwave and think, oh, I'd really like an amendment, you can bring that back to the committee, no problem, or you can put it down yourself and go and see the Bill Office all on your own, and if I'm sure we'll be glad to see you, and you can go through that.
I think there's broad consensus anyway in the committee in terms of the direction of travel and some of the amendments. So, as you say, everybody's entitled in their own right to.
Absolutely, and the department shouldn't be up there. So just to be clear, I'm just making it clear to members what they can do. It's not that should not be interpreted as a commentary by the clerk on the bill. It is not. It is just you have an opportunity. You may wish to use it or not.
Okay. Well, thank you both very much for your time today, and we'll see you soon.
Very impressive, Peter.
Peter, I think we should just take a couple of minutes, if you don't mind. Say 5. Well, say 5:12. We'll just come back. Allow people a bit of a break, and then we'll come back. So just go on to close.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound.
To public session. We're going to move now to item 8 on the agenda, which is the RHI bill and the proposed committee extension. Members, I just want to advise that the RHI bill, as you will know, passed the second stage on the 20th of October. A call for evidence as part of the committee stage has been launched. The bill obviously is quite short and includes related regulation making powers. The department has also launched the consultation on the regulations that are to be made after the bill has received royal assent. Members, if you look at the cover note at page 471, you will see that there is mention there in terms of an extension of the committee stage from the 9th of December to the 27th of February 2026 is suggested. Obviously we do not need to use all of that time. It can be done sooner, but that's to allow sufficient time for the committee to do its work. So are members content that we approve the following motion, that in accordance with Standing Order 33 for the period referred to in Standing Order 33.2 be extended to 27th of February in relation to the committee stage of the RHI closure of the non-domestic scheme bill. Members content?
Yes.
Yep. Okay, item number 9 is in relation to the SR on the RHI winter uplift tariffs. Members, the department has brought forward a statutory rule entitled the RHI Scheme Regulations 2025. The proposed rule is to come into effect in November 2025 and is subject to draft affirmative procedure and will therefore be debated in plenary. The rule will amend the RHI Scheme Regulations 2012 to increase the tariff for support payments made under the non-domestic RHI scheme to accredited small and medium biomass installations. The increases are for heat generated from November 25 and are to be based on meter readings recorded by Ofgem. The rule will fix the tariffs for these installations for heat generated up to the end of March 2026. The winter uplift tariffs are understood to be the same as the closure payment tariffs that are currently out for consultation. The committee considered SL1 on the 5th of November 2025 and had no concerns. Members, are there any questions or concerns that you want to raise at this stage? If not, members, I will put the following motion to the committee, that the Committee for the Economy has considered SR 2025, the Renewable Heat Incentive Scheme Amendment Regulations 2025, and subject to the report of the Examiner Statute Rules, recommends that it be affirmed by the Assembly. Is agreed? Yep. Okay, members, item number 10 in relation to chemicals and genetically modified organisms, SL1. Members, the Department intends to lay a statutory rule entitled the Chemicals, Health and Safety and Genetically Modified Organism Contained Use Amendment EU Exit Regulations Northern Ireland 2025. The rule is subject to negative resolution procedure and will come into effect on the 17th of November 2025. The Department has provided a draft copy of the proposed rule. The Department has also indicated that as the rule is cross-cutting in nature, it does require executive approval. The Department has advised that the executive has not yet considered the proposed rule. Under the Windsor framework, it appears that this has had to be disapplied. Clerk, would you just explain in terms of the Westminster Statutory Instrument?
This is a complicated one, members. I had the committee wrote off to the department to get an answer, and you can see their answer at page 486. So what apparently happened was a previous Westminster Statutory Instrument altered the regime for the authorisation of the use of biocide products and genetic modified organisms across the whole of the UK. Under the Windsor framework, it appears that this has had to be disapplied to Northern Ireland, and the original EU rules reapplied with some typographical changes, changing the reference to EU member states to Northern Ireland, etc. And for the GMO regulations, a reference is also added to medicinal products for veterinary use, marketed in accordance with the Veterinary Medicines Regulations 2013. So that's essentially what it's doing, disapplying UK rules in Northern Ireland, and under the Windsor framework applying EU rules. What the difference between the two rules are, don't know. But what the department told us, what it says in the paperwork they sent me before, was this applies from the 17th of November. My understanding, it hasn't been to the executive, and the department aren't able to clarify at this point what's going to happen.
I would have, just before bringing Jonathan, it would have some concerns just in relation to obviously the process and sort of that disapplication of UK law and applying EU law. Jonathan, do you want to come in?
Yep, thanks, Chair. Just checking you can hear me.
We can hear you clearly.
Yes, and thanks, Peter. So just to clarify, your understanding is that this hasn't come before the executive as of yet?
That was what we've been told, yes.
Okay. Well, look, just it will come as no surprise. I'm not content with this rule, given that in theory it seeks to define in law how Northern Ireland will be on the same basis as EEA countries for the purposes of whether it's chemical enforcements, inspections and risk assessment, all at the behest of the Windsor framework itself, which is something that we, as a party, we firmly believe has placed continued barriers to trade between both GB and Northern Ireland. So the intent of the regulations, whilst I accept may be well intended by some, but the reality is that the overarching political arrangements that they're are essentially a product of are unsustainable, and we'll continue in our campaign for their removal. So I would propose that the committee pray against the rule. Okay, so we have a proposal that the committee pray against the rule. Now, I'm conscious there'll be other members who may want to speak. Do we have a seconder for that proposal?
Sorry, Chair. Just to clarify, seconders aren't required.
Okay.
Also, the rule hasn't been laid yet, so you can't really pray against it because they haven't actually laid it. But what you could do, if you wished, okay, you have several options. You could defer consideration till we know what's going to happen, or you could vote because what the department is looking for is a response from the committee about whether they are content for the rule to be made. The rule has not been made yet, so you could vote against that if you so desired.
Okay, so just to clarify then, what is actually happening right now, they're asking us whether we're content for it to be made, so we wouldn't, I thought whenever it said by negative resolution, it meant that we had to pray against. So your understanding is I can amend my proposal to say we vote against it being made. Is that your understanding, Peter?
That's it, yeah. So the rule, so the members know how this delegated legislation stuff works, is that they bring an SL1 to us, and there's the committee's opportunity to highlight any concerns that it has. If you have none, then they will make the rule, so that means they give it a number, and they lay it in the business office, and then it comes back to us again. So you could oppose the laying of the rule if you wish to, and then once it's laid, you could oppose it again. And you could also, as an individual member, if the committee is minded to support such a rule, you could pray against it as an individual if you so desired.
Okay, so we're not at the stage of praying against, is what you're saying?
Correct, we're just at the making bit. That's right.
So I could amend that to say that I propose that we vote against it being laid?
Yes. It'd be made and laid.
Made and laid. Well, I would amend my proposal to say just that.
Okay, and we don't need a seconder on that?
No.
Okay, all right. Are there any other views on the committee?
Yeah. No, I mean, look, we're happy for it to come back again and to have further discussion then, so we won't be voting.
Any other
Johnny?
views? No. Okay, so there are really two options. Sinead? No.
Sorry, Chair.
Sorry, what did you say, Sinead?
Here.
Yeah, no, you're okay. Sorry.
We're okay for it to come back again. We'll not be voting, or I'll not be voting either.
Okay, and Padraig?
No, I wasn't trying to come on there, sorry.
Oh, sorry, no. Apologies, there's a bit of a delay here as well. So basically, look, what we'll do then is we'll move to a vote in terms of the proposal to not lay the rule, or not support laying of the rule. And then we will making them the lay of the rule. And then what we will do is there's other members who suggested that they're content then to effectively delay is the wrong word. Wait for defer is the right word, I think, in terms of waiting. So let's deal with the proposal, which is that we do not support the laying of the rule.
Okay, so it's to oppose the laying of the rule is the motion.
Yes.
Okay, so
in four.
So okay then.
This is so just to clarify, because we're in favour of opposing the laying of the rule. Is that right?
Yes. So those voting aye or opposed to the laying of the rule. So
I have indicated, and Jonathan has indicated, and Diana has indicated, and those who are not in favour of that is David and Kate and Padraig and Sinead. Okay.
Right. Very good. Thank you very much.
So that's 2, and then
it falls.
That falls. So there's obviously then a proposal to defer this in waiting for clarification from the executive on their position.
Okay.
Yes.
Do we need to vote on that?
I don't think we need to vote, because that's the option on the table now. We've already voted. Are members content then that, having the vote just been taken, that we now defer this and wait for the executive position? Yes.
Okay. Very good.
Content? Okay.
No dissenting voices. Let's move on.
Let us move on to correspondence. Correspondence, members, there's a number of items in the correspondence, so we take you to page 533 of your meeting packs. And Clerk, do you want to maybe take us through? Sure. There's a number of items there.
I think that the chairperson is suffering and has been
apologies by yes,
so, and I'm not. So members turn to page 533 is where the index of correspondence is. So the first item is at page 535, it's item 2 actually. This is a ministerial written statement advising of a further extension of the running hours for Kilroot Power Station. As you remember, members, we had an informal meeting with the utility regulator where they talked about this, and we kind of thought this was only going to go on to about now, and this is going to run on. I think we're being told Kulkera will not be back in operation until mid-December, the statement says.
I think we need to obviously write to the utility regulator, apologies, seeking an update on Kilroot, but also we need to get clarification in terms of Kulkera, because we had received information that would have been online, certainly if not already, but imminently. I have a number of members indicating. I think Johnny, you were first, and then David.
Just briefly, and I know it is concerning and it is quite technical, but do we have any indications from the Minister about what additional costs this is to Northern Ireland? I'm conscious when we're in times of difficulties, particularly in this, the theory of, extensions in terms of running hours sounds good in theory, and indeed probably keeps the lights on, worrying that we've got to that stage. But what additional cost to the Northern Ireland taxpayer is that?
Okay.
So, Chairperson, does the committee wish to write to the Minister asking that very question? What will be the additional costs?
Yeah. Yes. We can, Johnny, we can take that forward and ask for those costs. David?
Just on your point about Kulkera, we've been told constantly that this is coming back at a point. We were told 14th or whatever it was of October. Then so we need to know what's going on there really, and what's more detail on that, and how we move forward really from there.
Hopefully the utility regulator might be able to provide some light in respect of
and the Minister too,
and the Minister as well, of course. Diana and then Padraig. Diana.
Chair, could I ask, there's additional run time has been granted. When do you get to the extent of that run time that is permissible legally?
That's a good question. Again, we'll ask, how long can you keep doing this? Is the yes.
On the 1st of January, isn't it? It was over 5 years. It was in the... So it's the average over 5 years, I think, but it's from the 1st of January. Is the
we can seek clarity on that point as well. Padraig, as indicated.
No, look, the points have largely been clarified. I just think that the more clarity we give now around exactly what we want to know, because I'm conscious that the last meeting we were kind of we asked a lot of questions, but the more direct we can be now, the better. So I think people are being specific on that. I mean, I'm just broadly content with the questions that have been raised so far. I mean, the timeline is the most important thing, and the contingency plan. So I think if we're really specific in what we're asking, that'll make it easier, but I'm content with what's been raised so far.
Oh, absolutely. So we're specifically asking in terms of the costs to date, in terms of those additional extensions, from the Minister. We're speaking to the utility regulator in terms of Colkira and when we've obviously got an indication it could be back on in December, but we've been told numerous dates, and we need to understand why that keeps been pushed back. And there was a third thing, or is that?
It's just to Diana's point.
And Diana's point, sorry, yes,
how
in
long can
terms
you keep
of
doing
how,
this?
how sustainable is these extensions? Yep, and of course there's cost implications to that as well. So, okay, members, content, agreed? Yeah.
Item 3 then is actually from the utility regulator. This was in respect of Kilrea Power Station's request for a code modification. So as part of that letter, the utility regulator, if members are content, would just ask for a better explanation of what that was, because I didn't understand that.
And we'll include that in the letter.
Yeah, that's agreed. Item 4, page 544, there's a press release and a copy of the disclaimed Department for the Economy Annual Report and Accounts for 24-25. Members might wish to note that the DFE Audit and Risk Committee expressed some considerable disappointment to see further issues emerging in the 24-25 accounts which have been added to the NIO disclaimed opinion. It is also a concern to that committee that several of the substantive issues identified in the 23-24 audit remain unresolved. Now the department and the minister are actually going to come to see us in January to talk about budget, but they'll also talk about hopefully business plan and their annual report and accounts too. Members are content?
Yes.
Okay, 5 then is correspondence to the Committee for Finance providing further information on the Presbyterian Mutual Society write-off. So we'd heard about this previously. This is just a formal minute, and there are some questions about it. If members are content to note.
Yes.
Item 6, members are asked to consider a departmental correspondence in respect of a Westminster instrument allowing the Scottish Government to restrict the sale of glue traps. Okay, so is the committee content to respond indicating that perhaps it has no concerns in respect of the sale of glue traps being restricted in Scotland, but seeking further information on the UK Internal Market Act from the department? So this is, I think what's happened is these glue traps, I think you catch like rodents or something in them, and they get stuck in the glue, and it's not a nice way to die. So I think the Scots have decided they're going to not have these in Scotland. Fair enough, that's up to them. But there are implications for the UK Internal Market Act, so that, say, producers of glue traps in Northern Ireland, if there are such things, would then not be able to sell their goods into Scotland. And that's sort of where this is coming. So if we're content to seek some clarity from the department on the UK Internal Market Act and what that means.
Yes, so we're proposing we seek clarity from the department as to what it means. Yes.
But I think members are content enough about the contracts.
We're content that,
Yep.
yeah.
Yep, okay. Item 7 then, if that's agreed, is departmental correspondence in respect of a Westminster instrument applying the Clean Heat Market Mechanism Amendment Regulation 2025. What this does, it obliges manufacturers who sell a minimum specified volume of gas or oil boilers per year to meet heat pump installation targets of 6% in 2025 of their relevant fossil fuel boiler sales or requiring credits. A small number of local operating manufacturers are understood to fall within the scheme. Is the committee content just to seek clarity from the department on what the actual consequences for local manufacturers may be?
Yes.
Yeah.
Okay. Very good, thank you. Sorry, members. Number 8 then, members are asked to consider at page 801 correspondence from the Assembly Executive Review Committee referring to its review into the development of a formal process on the handling of Westminster statutory instruments, including a request for examples. So those last two things, so those are basically, they're not LCMs. What they are statutory rules in England that apply in Northern Ireland. Right now there is no process. The department, the minister is very obliged to told us about these things, but previously, in my previous experience, we would not have been told. So ARC are looking into this. Is committee content for me to go back to them and give them a few examples of ones that we've seen? Very good.
Both Jonathan and myself are members of the Assembly Executive Review Committee, just to take a note if Jonathan's happy that I declare that in our behalf.
Declaration of interest.
Yeah.
There you go. Very busy. Anyway, okay, so item 9 is page 808. This is the ESR's 49th report. She refers to the Student Fees Amounts Amendments Regulations Northern Ireland 2025. She had no comment on the rules, so if members are content to note.
Yep.
Item 10, page 816. This is TEO giving us really a holding response in respect to the development of the international relations strategy, if we are content to note.
Yeah. Very helpful.
Number 11 is, this is a response from the Minister of Education. So if you will recall, when the Skills Council came, they made reference to the status of Level 2 Essential Skills qualifications. it seemed to be implied that they would no longer count into the performance points for schools, but the Minister has indicated that's not the case. They still do count. I think Ms Nicol has a comment.
Yes.
Yeah, just a comment. I actually put a question in about this in terms of engagement with employers, and the Minister for Education came back and said, well, didn't have to really engage with employers, and I just think that speaks to the silo mentality of so many of our departments, in that obviously they're focusing on their stakeholders, but with things like this, it's so important that we engage with employers. So I just wanted to make that point. I think so often things are done by just the way the norm is, but when these educational decisions are being taken, they have a direct impact on employers, and there needs to be a better link up, I think, even just in seeking their views.
That's recorded in the minutes. If members there are content to forward the response to the Northern Ireland Skills Council who raised the issue. Okay. Number 12 is a copy of the correspondence from the Department of Finance providing an update on the review of arm's length bodies. So the committee content to note we've received a couple of the arm's length body reviews. So committee content to note.
We are.
Number 13. Correspondence from the House of Lords and NI Scrutiny Committee to DBT in respect of proposed amendments relating to digitalisation and common specifications. It doesn't tell us very much. Is the committee content to note?
Yes.
14. Members are asked to consider a request from, this is page 827, Derry City and Strabane District Council to brief the committee on Go Succeed. Is the committee content for the chair perhaps to meet with them informally to discuss that issue, or do you actually want a formal briefing?
Padraig?
Just declare two interests as a former participant in the programme, but also obviously my local area constituencies.
So what would you like to do, members?
Well, I think in this instance it is an important piece of work, but I think if we propose that the chair at this stage informally meet and we get a report back in terms of some of the issues that are being raised, and I think that we certainly include them maybe in the forward work programme in the future in terms of maybe future stakeholder engagement. Kate.
Sorry, Chair. Yeah, just there's a Grow Succeed event in the Long Gallery next Tuesday, Enterprise at the Heart of Growth, so it may be of interest for members to go and be briefed there.
So we've agreed that the chair will informally meet with the group, and as I say, maybe look for opportunities in the future as to how we could engage with them.
Okay, thanks. Okay, that's great then. Item 15 is at page 829. This is an invitation from the Bar of Northern Ireland to attend their event, The Rule of Law in Perspective. So if members are content to book that individually if they wish to attend. Is that the details? That's great, very good. 16, members are asked to note a copy of correspondence from a concerned individual to the Retailers Association Northern Ireland in respect of Halloween ephemera. So is the committee content to note?
We are.
And then 17 are asked to note a copy of correspondence from a concerned individual to the utility regulator in respect of Wayleaf arrangements and payments. Committee content to note. Thank you. Can I ask chairperson if members have any queries in respect of any other item of correspondence?
No, everybody's content. Okay, so we'll move then item number 12, which is forward work programme. I refer members to page 850, and again the clerk is going to take us through next week's meeting, which is going to start.
No,
it's not going to.
No, because we've done our job there. So we will start at our usual time at 10 o'clock. We're just going to have to shuffle our witnesses around. But just to advise, so that's the 19th. So we don't need to touch the bill again. We'll just hear about AI from Matrix and from NFDA about car registrations. Then on the 26th, we'll come back and do the formal clause by clause of the bill, which should be quite straightforward, I think. Also on the 26th, it's proposed that the committee takes evidence from Professor Rooney, who has developed the tariff model for RHI, and then from RHA, the Renewable Heat Association in Northern Ireland, on the 3rd of December, if members are content with that. Also, if you remember, the Chartered Accountants Ireland had written to us, they're seeking to brief on corporation tax. So it's proposed what we do is have an informal lunch with our colleagues with the Committee for Finance on Wednesday, the 21st of January, thank you. So what we do is we do our meeting, we do our meeting, we pop up the stairs at 1 o'clock, meet with the accountants, and they'll tell us what they think about corporation tax, and then members who have meetings in the afternoon could nibble on the next one if that's okay. Then the committee visit to Skills for Life and Work providers, propose we do that on the 11th of February. Again, we would it would be in Belfast, so I think there's one on they're not on the falls, but they're near the falls. One's on the falls, one's on the Shankill. So we would do those, and that would be something we'd do at probably lunchtime on a Wednesday on the 11th of February. Members are...
Lunchtime, we'll go with the majority of members, but it's certainly difficult for those of us who are on committees in the afternoon, but it is what it is. There's no better time, I suppose, and that's the difficulty, so just go with it. Yeah.
Okay, and then, the department's indicated that they'll come and talk about the skills action plan and the sectoral action plans on the 18th of February, a bit later than we thought, but there we go. So if members are content with the forward work programme as amended?
Yeah.
Thank you.
Okay, members, any other business? No, everybody's content. Date and time of next meeting, so we've decided that's 10 a.m. next Wednesday here at room 30, Parliament Buildings, and I put the question that the committee now adjourns.
Thank you.